don't create the problem for you and the company to defend later.
Correct. And definitely don't be like this guy at the Walmart in Ottumwa, Iowa, and tell the person, I'm not giving you the promotion because you're a mom of young children.
So even if you're going to discriminate, don't admit to it and don't give them, certainly don't put it in writing. Good morning, HR. I'm Mike Coffey, president of Imperative, premium background checks with fast and friendly service. And this is the podcast where I talk to business leaders about bringing people together to create value for shareholders, customers, and the community. Please follow, rate, and review Good Morning HR wherever you get your podcast. You can also find us on Facebook, Instagram, YouTube, or at goodmorninghr.com. Well, this is the last Thursday of January 2024, which means it's time to review recent news in the HR world. Joining me this week to recap a few interesting people-related stories is Patrick Richter. Patrick is a partner at Rigby Slack, an Austin-based law firm serving businesses across the U.S. Patrick is board certified by the Texas Board of Legal Specialization in Labor and Employment Law, and he represents employers nationally in all types of employment disputes, including class and collective actions. He also has considerable experiences with matters before the National Labor Relations Board and in assisting clients with union avoidance. Welcome back to Good Morning HR, Patrick.
Thanks for having me.
It's appropriate that you're my guest this month because way back in episode 77, last January, you and I discussed the Biden administration's then proposed rule concerning independent contractors. And here we are a year later, and the final rule was was published on January 11th, and it's expected to take effect in around March 11th. So the final rule could impact everything from gig economy workers like Uber drivers and freelance writers to real estate agents. So let's just recap. What does the final rule define as an independent contractor, and how is that different than the previous rule?
Well, it's more like how it defines what's not an independent contractor, right? Basically, there's a presumption that workers are employees and they're only independent contractors if they're economically independent from the company that they're providing services to. To be honest with you, this feels like Groundhog Day to me in a lot of ways. You know, it's another rule, it's another kind of hyped as if it were a big change, but we're just sort of reshuffling the deck chairs on the Titanic, for lack of a better analogy. I've been doing this for 30 years, and there's always been a multi-part, multi-factor test for independent contractor, and the courts and agencies say there's no emphasis on one particular factor or the other, and so you're always in this feels like loop of, are they an employee or an independent contractor? And how can we, if we want them classified as contractors, how do we mitigate the risk that somebody comes back later and says, oh no, I was misclassified, I should have been an employee.
So economic dependence, if I have, let's say I'm just a solo practitioner, an HR consultant, and I primarily serve one company. And, that company calls on me with a pretty regular, maybe I have some regular tasks for them, and they call me in for special consultations, and maybe I handle their employee relations and just, the stuff that an HR consultant does. But I just primarily have one client. It's just project work, but it's pretty consistent. Am I at risk as the as the employer as the company who's working with this 1099 contractor of being in trouble for not paying them if it's some week they work 50 hours and I don't pay them overtime?
Yeah, I mean, maybe is the answer. The way that the new rule says, it lays out the 6 factors instead of 5, and it says it's opportunity for profit and loss, the nature or the amount of the investment by the worker and the company. Where you're in this situation and you're hypothetical, you're getting tripped up is the permanence of the work relationship, which I think is a big factor. And I think it ignores, some reality. I think there are businesses where people are happy to be labeled a contractor, work kind of when and as needed, but like you were just saying, only work for one company. And, since this rule came out, I've had a couple of conversations with friends and clients and thinking about it on my own. And I don't know how you draw that line, like when that's okay and when it's not okay.
I think it's okay when everybody's happy, right? And it only becomes a problem when when the contractor is suddenly unhappy with their circumstances.
I think that's exactly right. You get in these situations where somebody's a long-term independent contractor and they like it, and then the relationship ends for one reason or another, and then they go talk to somebody and they, I should have been classified as an employee all along. The other three factors are always the nature and degree of control, which is another one that gets hung up on. And then whether the work's integral to the business. I think in your hypothetical of being an HR consultant, that's probably not the case. You're ancillary to what the business's main mission is. But when you have, for example, a software company that would hire independent contractors to come in and help write code, there's no question that those guys the work they're doing is integral to what the business is doing. And then the last one is skill and initiative. And I don't know how you weight that. I don't even know if the people who wrote the rule know what they mean when they write that.
Well, and there are 2 lawsuits now, at least, against the DOL's final rule. And they both pretty much read the same. I think they both say that the rule's too ambiguous, and that's what the legal arguments they're making are. But on the practical side, publicly, they're just saying this is going to wipe out the gig economy, or this is going to, pull a lot of people into employment who don't want employment, freelance writers and people like that.
I just don't know that it's that big a sea change, to be honest with you. It is tweaking the rule. It is, the old rule, the one they put out in 2021 had a particular emphasis on a couple of the factors over others. And this is trying to just reweight that. I don't see it as, a massive shift. So in other words, if you were a gig economy worker in 2023 and nothing changed, you're at the same level of risk to being classified as an employee in 2024, I think, as you were 6 months ago. I don't know that it changed that much.
I think it was the National Association of Realtors published on their website advice to realtors who don't want to become employees of the brokers that they work under. They work under these broker licenses and use the broker's branding in their marketing and stuff, but are apparently largely independent contractors. And I didn't know that. But one of the things that caught my eye that sounded dubious in that blog article on the NAR website was that you should have, the realtor should have an independent contractor agreement that, states you understand you're an independent contractor and you're not our employee. Does that make any difference under the regs? Or are you waiving, is that employee actually waiving their rights to a claim later? Or
I don't think it would operate as a bar or a waiver, but I would certainly do it. I think if you have workers who you're going to engage as independent contractors, you should definitely have an independent contractor agreement with them. And it's just another piece of evidence of the nature of the party's actual relationship. And so someone who goes to the trouble of sitting down across the table from you and reading an independent contractor agreement and signing it and making all those acknowledgments, it's just one more thing that's helpful if after the fact they try to change their mind and say, I should have never been an independent contractor. But I don't think it's certainly not determinative.
And the other thing I hear a lot is that if you're going to be an independent contractor, our company will require that you have a corporate entity that we pay, that we're paying a corporate entity rather than you directly. Do you think that really will make a difference or help an employer's defense?
I think similar to the contract. I think, it'll help. It certainly shows that at the time they entered into the relationship, the parties, considered and, contemplated and addressed this issue of being an independent contractor. But, I don't think the DOL in particular is ever going to look at that and say, oh, you had a contract and you set up your own LLC. Oh, then hands off. We're not going to ask any more questions. But I think it doesn't hurt.
Right. Well, and I think this is going to end up like the Weingarten rule. Depending on which administration's in charge at any given time, it's going to swing back and forth. I mean, they just repealed the Trump administration's rule, right? Is when they implemented this one.
Right. Well, they did that in 21 because
Yeah.
there was an original rule in 21 that was Biden, and now this clarification in 2024. But
So depending on what the election does later this year, we may see in 2025 something all over again, a little different.
yeah, and this DOL change is strictly for purposes of applying the Fair Labor Standards Act. It doesn't, at least technically, doesn't apply to state level laws that can be different, or the question of whether someone's an independent contractor for things other than minimum wage and overtime.
So like the IRS rules, you could qualify maybe under the IRS rules, and not, so the employer is not expected to do withholding, all that, but under the DOL side, you could still have
Potentially
an issue. Yeah.
Yeah. And I think, though, once something like this gets adopted and courts start applying it and you get cases out there and opinions, it sort of becomes the default. But my bigger takeaway on this whole independent contractor thing for 2024 is I really don't think it's changing much. I think, like I said, if you were an independent contractor in November of 2023 and you operate under the same terms and under the same rules as you did then, you're at the same risk anyway. Whether you are or not, I don't know. But I don't know that this change made a huge difference in that fact about whether you are or not an independent contractor.
And there's litigation, so we'll see this. It just takes one court in the Northern District of Texas to put something on hold, and so this could all be on hold before March 11th.
It's actually interesting, there's that case that just got argued before the Supreme Court about agency
Chevron?
deference.
Yeah. And we talked about Chevron, I think, last January.
We did. Under similar circumstances, talking about the wage and hour cases. If somebody gets a judge to bite on that, and look, if the Supreme Court says there's no Chevron deference, then who's the DOL to say what the factors should be? And, the wrong judge or the right judge, depending on your perspective, might say, oh, that's something Congress has to actually spell out in detail in legislation. And if they don't, the agency doesn't have the power to make a rule or make an interpretation of it. So it'd be real interesting to see what happens with that litigation.
Yeah, that case, is supposed to be heard, I think, or decided by the end of this term, right?
The Supreme Court case on Chevron, yeah. But then the trickle-down impact of that on any of these lawsuits about the DOL's final rule.
Mm-hmm. Well, it'll just create a ton of lawsuits. I mean, if Chevron goes, if the Supreme Court agrees that Chevron's dead, the plaintiffs representing business interest and everybody else will start just picking their cases. It'll be full-time employment for the Department of Justice for the next decade, probably.
Well, and for attorneys, right? I mean, if Chevron deference goes away and basically every regulation by every agency is subject to being struck down because it should have been, Congress lacked the power to delegate it, and so it goes back to the statute. There's any number of things are going to be, completely wiped out. And interesting to me, I listen sometimes to a podcast that's just the oral recordings of arguments in front of the Supreme Court. And some of the justices who are, I think, leaning towards overruling Chevron were talking about how every 4 or 8 years, there's sort of this chaos of reinterpreting regulations. Well, I think the chaos of that every 4 years is going to pale in comparison to, every regulation basically being subject to being challenged and Congress having to legislate with extreme specificity, something like what's the test for an independent contractor or an employee under the Fair Labor Standards Act. That's just going to be a mess.
And if there's one thing Congress hasn't liked doing for the last 2 decades, it's actually legislating. I mean, and
Correct.
actually, dealing with, issues that call for compromise, especially, and coming through to create, rules that, either split the baby in half or please all sides or whatever. And so
it would grind almost everything to a halt.
The anarchist in me kind of wouldn't mind seeing that. It might be kind of fun, but so. And again, if you want to dig deeper into all of that, episode 77 from last January is in your podcast feed or at goodmorninghr.com. So Then we had a couple interesting lawsuits that you kind of wonder if it's just a result of a single knucklehead manager or if it's something more pervasive in the company. But the first was that a company called Perdue Foods settled a lawsuit related to accommodations under the Pregnancy Discrimination Act and the Americans with Disabilities Act. And basically, pregnant employee, she calls in, calls out of work, calls in sick for a few days because she had some sort of infection. And as she was preparing to return, she told them, I'm going to need regular access to water and a bathroom. In other words, she's pregnant. I mean, that's just, that's kind of a symptom of being pregnant. But she's going to need regular access to water and a bathroom in order for her to be able to return. Somebody in HR determined that they couldn't accommodate her and instead said they're going to put her on leave and that she should qualify for short-term benefits. And then eventually they fired her, citing all her extended absence. And so a settlement doesn't mean the employer was necessarily truly liable or even in the wrong, but they just decided to pay this to make it go away rather than dealing with it. But what are the takeaways here for an employer dealing with a pregnant employee who's asking for some sort of assistance?
Well, don't force the employee onto leave as your version of the accommodation without talking with the employee about what they would prefer. Number one. Number two, there was some evidence in that case. I shouldn't say evidence. There was pleading in that case in the plaintiff's original complaint that the HR manager responsible for evaluating her request for an accommodation was notoriously hostile to accommodations for pregnant women and had, according to the double hearsay in the complaint, had never approved an accommodation for a worker who was pregnant. Other than that, the takeaway, I think, is, evaluate each case kind of on its own merits. Don't have a knee-jerk kind of blanket response to someone saying, I need a rest, or I need access to the bathroom, or I need water. The other big takeaway, and I say this to clients all the time, is you should give the employee the accommodation they're looking for unless it's an undue hardship. And you being irritated about the employee having an accommodation is not an undue hardship.
And it's the Americans with Disabilities Act. I mean, does it sound like, just again, going by the pleadings, that at least in good faith, Perdue went through that interactive process that, that's really called for in ADA guidelines?
Right. And there's a statute, it's relatively new, the Pregnant Workers Fairness Act, that specifically addresses this issue of accommodations for pregnant employees. And it has in it some examples of things that are, they can't make it be a reasonable accommodation, but they suggest that in most cases they will be. And it is, the ability to sit, drink water, park closer to the building, have flexible hours, break time to use the bathroom, things like that, maybe an employer who's not as interested in accommodating their employees might shoot down without really considering it. And it requires there to be an actual interactive process, much like the ADA.
Okay, so the Pregnant Workers Discrimination Act was passed in 2022. The EEOC is writing the implementing, or has published, I think, a preliminary version of the implementing rule. Does that mean the law is not really in effect until after the EEOC's guidance is published? Or could a plaintiff bring something under the Pregnant Workers Disability Act right now?
I think someone could bring a claim under the Pregnant Worker Fairness Act. I think it just, just the difference would be you don't have that EEOC interpretation.
Mm-hmm. So it goes back to the courts, which is kind of what Chevron's all about, right? Did we write the law in a way that's easy for companies to understand and for the courts to interpret? And basically, the Pregnant Workers Fairness Act is basically a mini ADA just pointing at pregnant employees, right?
I think there were some cases out there that had treated pregnancy and pregnancy-related medical conditions and impairments differently. And I think the PWFA was just intended to close that gap and say, no, look, you have to accommodate people in your workforce who are pregnant who have these issues, whether or not they rise to the level of being a disability or otherwise. Yeah.
So it was just kind of a hard month for employers with pregnant employees or who are mothers. It's just like we couldn't do anything right this month. So Walmart agreed to settle a sex discrimination lawsuit for $60,000, and the EEOC alleged that Walmart in Iowa denied, which is probably one on every corner in Iowa, denied a department manager a promotion because the employee was a mother of young children. And the plaintiff or the EEOC claimed that in explaining to the employee why she wasn't getting the promotion, they specifically mentioned that she was the mother of young children. So, and the settlement came after the federal district court, and their motion to dismiss said, pointed to a Supreme Court case that said that the presumption that women prioritizing motherhood over work is an impermissible sex stereotype. So $60,000, small settlement. This probably wasn't widespread across Walmart, but it's another case where one manager saying the wrong thing can cause you some real issues.
I think that's definitely the case of the knucklehead manager that you mentioned before. Somebody who would be as explicit as saying, you're not getting this job because we have concerns that, you won't have the time needed because you're a mother of young children. That really, really, really bad management. Yeah. And I didn't think about it till you just said it, but maybe it's a small settlement and maybe it didn't go any further because they knew they had a knucklehead manager and they knew they had bad facts and they wanted to get it settled before the EEOC found 10 or 12 or 20 more people in the same boat at Walmart's in and around Iowa and turned it into a class action, Yeah,
it may have been the cheapest route. I mean, $60,000, Walmart spent 3 times that on attorneys just getting to that point, right?
I mean, maybe. But, I always tell people, the really bad cases, the ones where the company kind of did it, and at least with my clients, when I feel like they've been, they had a bad manager who said the wrong thing, I'm trying to settle that case as fast as I can because it's only going to get worse. When you're fighting a statutory claim where if you lose, the plaintiff is going to win their attorney's fees. Like the harder you make it, the more you fight, you're just making the end result worse. So settle it as fast as you can and get out. And $60,000, that's probably a pretty fair settlement for a case like that.
So when can an employer consider an employee's status as a parent?
I mean, to me, almost never, because you're almost, without question, you're stereotyping one way or the other. And that's exactly what Title VII, gender discrimination, is supposed to keep you from doing, is assuming somebody can or can't do a job or is or isn't fit or whatever based on their gender. And if you're stereotyping an employee and saying, oh, because you're a parent, you're not going to be able to meet the hours requirements, that's, the definition to me of discrimination. So your job there, though, is to, if you hire the most qualified person or hire the person you think is the best fit. And then if there's productivity issues or other issues, attendance issues, you just have to manage the employee through that.
And so the generic big box retailer manager who says, well, every time we hire somebody with young children, they're late, they call in late, they're unable to work opening shifts, and things change. We always have these issues. That's always my experience. You're telling them just hire people who are otherwise competent, but maybe check with their previous employers. Were they consistently, working the schedules they were supposed to work back then? What was their job performance? And looking at past performances, predicts, future performance to some extent. So do that kind of stuff. But as far as their actual status as a parent, it's hands off. Just don't create the problem for you and the company to defend later.
Correct. And definitely don't be like this guy at the Walmart in Ottumwa, Iowa, and tell the person, I'm not giving you the promotion because you're a mom of young children. So
even if you're going to discriminate, don't admit to it, and don't give them, certainly don't put it in writing. But
that's definitely my advice. If you are going to discriminate, don't put it in writing.
Dumb, yeah, don't do it. Don't double down on it and put it in writing. And let's take a quick break. Good Morning HR is brought to you by Imperative, premium background checks with fast and friendly service. At Imperative, we help clients make well-informed decisions about the people they involve in their business. This includes very thorough employment-related background investigations, but also all kinds of due diligence on vendors, clients, investment targets, or even joint venture partners. We're waiting to be of service at imperativeinfo.com. If you're an HRCI or SHRM certified professional, this episode of Good Morning HR has been pre-approved for 1/2 hour of recertification credit. To obtain the recertification information, visit goodmorninghr.com and click on Research Credits, and then select episode 132 and enter the keyword Richter, that's RICHTER. And if you're looking for even more recertification credit, check out their webinars page at imperativeinfo.com. And now back to my conversation with Patrick Richter. The other thing that comes up with parents is, and it's come up with some of our clients as I've had conversations, I've even seen it on HR job boards or on HR discussion boards and in job postings. These remote employees who have small children at home, and employers are concerned that, well, if this person's, especially if they're remote and they're hourly, and they have small children at home, they're not going to be able to give 100% of the focus that we need for this person doing the job if they're taking care of small children. And so I keep seeing references to policies or job postings that say, if you're working remote, you have to have childcare for any children under X age. Do you think that had passed muster under Title VII?
I think that's dicey for sure, and I sure wouldn't recommend it. Because again, I think you're sort of stereotyping the employee and their ability to do the job. Maybe there's somebody else at home. I don't know what having childcare means in that context. Do you have to employ someone in the home? Is your other parent or partner or spouse sufficient? I also don't know how you would police that.
Yeah, that's the thing. That's my concern. As HR, how are we going to monitor that? Are we going to start keeping a list of certain employees with children and certain employees without children? And when the first time you take some sort of disciplinary action against an employee who, because they don't have child care for their small child, what about all the other employees that you may or may not know about who don't have who are in the same situation?
Right.
So
we're gonna bar you from working remotely unless you affirm you don't have Netflix. So you can't sit.
Exactly.
You can't sit on your couch and watch TV.
Exactly.
No, my guess, Mike, is that putting that in a job description or putting that in some kind of posting is a little bit of a way to self-select those people out of the pool of applicants more than anything else. I'm not saying that anybody in particular is doing that on purpose for that reason, but back to your example, and it's a crossover a little bit, but the manager who has experience with employees with young children, and that those employees are late or less productive or whatever, baking that into the job listing is a way to screen those people out on the front end, maybe.
Well, that's the, when you look at a lot of the fair chance hiring ordinances across the country, some jurisdictions are saying you can't mention, things like clean background check required, or even mention the existence of a criminal background check process until after you've made an offer. New York City being an example of that. So, the thought is, and I'm not sure I agree with the reasoning, but that you're dissuading applicants just by even saying that we're going to do a criminal background check, that you're dissuading people from applying. I think, depending on the industry, it probably makes some sense to weed those candidates out earlier in the process if their past behavior makes them your least ideal candidate.
Right. I think some of these statutes, I'm primarily a defense employment lawyer. So some of the statutes just seem like, hanging extra weight on our clients and how they want to go about doing business. But I do think some of them are well intentioned. And I think that's probably one of them. And I think where companies, hirers, employers run into trouble is you try to solve a relatively thorny problem with a blanket rule, right? Like if we don't want hourly employees working remotely if they're not going to be productive and they're going to be distracted. Okay, well, how are we going to do that? Well, we're going to write a rule that says if you're working remotely, you have to have childcare if you have a small child in the house. It's shifting the burden of really managing that employee and making sure they're doing what they're supposed to do from the company, whose job it probably ought to be, to the employee.
And it just makes I think it makes managers' jobs easier, at least in their minds, because now I don't have to manage performance. The first time I'm annoyed by this employee because I tried to reach them over Zoom and they didn't answer, and I say, and I happen to know that they don't have childcare. Okay, so they're not doing their job. So now I'm going to lower the boom. I'm going to use a stick to claim they're violating company policy rather than managing the employee, which is always more effort than, the manager often wants to take.
Right. And it's almost always the answer. If you call me and you say, hey, we have this issue, what do we do about it? I'm going to say you got to manage the employee through it rather than make some blanket assumption or a blanket rule and try to avoid the sort of hard work that you're talking about.
And then finally, there was a report this month. And these kind of reports are always kind of suspect to me when you look at, who's writing them. And this report was issued by a company that publishes an employer training and does employer training work, but the report was that employee non-compliance cost larger businesses an average of $1.6 million per year on average across those businesses. So that included non-compliance with HR policies, but also everything from cybersecurity to accounting. And we've talked about the cases related to pregnancy and how you're supposed to handle those and managing mothers and those kind of things. But, when we're talking about all these things, opening the company up to fraud because of your cybersecurity policies or your accounting policies or all the different ways that we've got policies and procedures in place, and then sometimes employees just don't comply with them. I'm sure you see examples of it almost every day in working with sure. your clients. When you're looking at an employer's compliance structure and how they educate their employees and how they monitor the compliance, are there things that you see that really work well that employers should really have as part of their program in making sure that their employees are complying with the policies and procedures?
I mean, I think the biggest thing is just communicating the policies in the first place. Handing an employee a 90-page handbook on day one and telling them to flip to the back and sign the acknowledgement that they read it is about what most people do. And I don't think that really is helpful. And the other side of that coin, I think, is, and I say this a lot to companies when they're asking me to either look at a handbook or help them put one in place or to revise it, is policies and procedures are great if they reflect what you actually do and you actually follow them. I want to be able to point to that when you go to let somebody go and you say, oh, this person was working remotely and they failed to follow our remote work policy. Great. But is that really the way the remote works at your company? Is that really, and are you going to enforce it for other employees, or are you just using it as a hook to get rid of somebody that you otherwise decided you don't want in the workforce anymore? So, the worst thing not the worst thing in the world, that's very much hyperbole, but a very bad thing in my experience with companies is a really well-written, clear, concise, employee policy manual that doesn't reflect the reality of how that company operates on a daily basis.
Well, and you get frontline supervisors, especially frontline managers, who say, yeah, that's the policy, but we need to get this work out the door, or we need to get this thing done. And so just do it this way this time. And, and HR will, they'll never know. And I think there's, sometimes the pressures that those frontline managers feel to deal with the administrative burden of following the policies and procedures and just execute on whatever they're trying to get done. They put the employees in those situations where they sometimes push employees, here, we'll just, just do this and we'll deal with the other stuff later. And I think that puts the company at risk and certainly when you're talking about safety or things like that, puts employees at risk.
For sure, talking about safety, I don't think there's ever any excuse for cutting corners or bending the rules on safety. But there are a lot of other rules sometimes that, you just need an exception.
Right.
I don't think you can be sort of slavishly devoted to your employee handbook at times if it's going to stop you from getting the job done.
And you got to have a process for documenting that too. Here's what we did. Yeah. And here's why. Yeah.
And that needs to be, the exception and not the rule. You can't just have managers basically eviscerating the employee handbook by never following it. But I know that's definitely a balance. It's one of those things that you sort of have to take it on a case by case basis and say, in this moment, what's the most important thing, that we fill out these 17 forms before we finish this work, or that we finish the work and get it out the door, Yep.
Well, that's all the time we have. Thanks for joining me again, Patrick.
Thanks for having me.
And thank you for listening. You can comment on this episode or search our previous episodes at goodmorninghr.com or on Facebook, Instagram, or YouTube. And don't forget to follow us wherever you get your podcast. Rob Upchurch is our technical producer, and you can reach him at robmakespods.com. And thank you to Imperative's marketing coordinator, Marianne Hernandez, who keeps the trains running on time. And I'm Mike Coffey. As always, don't hesitate to reach out if I can be of service to you personally or professionally. I'll see you next week, and until then, be well, do good, and keep your chin up.